we'll just dive right in. This is the last case of the morning. It's 23-1586, Jocelyn versus Jocelyn. Appeal. Each side will have 20 minutes. Anybody have any cell phones on, please turn off or mute position. So, counsel, I guess if we're ready to roll. I have 5 minutes reserved for rebuttal. If you want a different amount, I'll switch that.
Your Honor, that's what I was going to ask for, so that's perfect.
5? Okay, good deal. All right, counsel, go ahead.
Good morning, and may it please the court. This case is before the court primarily because the final judgment.
You're Ms. Sussman, sir?
Yes, Your Honor, I'm sorry.
Right.
I'm Stephanie Sussman on behalf of the appellant Samuel Jocelyn. As I was saying, this case is before the court primarily because of a wholesale lack of required mandatory factual findings in the final judgment to support the trial court's awards of equitable distribution, alimony, and attorney's fees when dissolving the parties' roughly 12-year marriage.
The judge did make findings as to hourly rate and reasonable hours, right?
Yes, the final judgment does include a recitation of the total numbers set forth in the appellee's attorney's fees affidavit, and that there was no challenge to the reasonable hourly rate.
But it does actually recite the numbers of just $3.50 an hour and 62.9 hours.
Yes, it says the total number of hours spent, but when you do the math, if you multiply the hourly rate times the number of hours set forth in the final judgment, it does not equal the amount of fees awarded.
But it inures to your benefit.
Yes.
I mean, you don't want it at all, but I mean, the math was $57,000 and the judge awarded $36,000.
Yes, that's correct. If
You're not saying, well, you got the math wrong, please make it 57.
That would be correct, Your Honor. That is not the relief I'm requesting here today.
So. All right.
But I do think that goes to the point because there's a lack of explanation of how the trial judge reached her conclusions. It's difficult for, first, myself as appellate counsel who did not try this case, and then this court to go through the review that we're supposed to go through in an appeal, where normally we would be applying an abuse of discretion standard to decisions related to alimony, attorney's fees, and equitable distribution.
You saying lack of findings by itself is reversible?
Yes, Your Honor.
Do you have to allege or show us in any way how your client was harmed by those lack of findings?
I don't believe so, and I can get into the harmless error analysis because I believe that's where the court's going. To start, I acknowledge there is no transcript of the proceedings below. That's because there was no court reporter that attended the trial, and despite our best efforts, we were not able to find any electronic recording of the proceedings. So there was not able to be a transcript prepared. And then, so in normal circumstances, that would be a large problem for an appellant, and I acknowledge that. But this court's case law, most of the case law of your sister courts, and I believe the Florida Supreme Court, address that where there is error that's clear on the face of a judgment, and specifically with regards to a lack of statutorily required findings, the judgment can be reversed even in the absence of a transcript of the proceedings below, because it completely hampers this court's ability to undergo the appellate review that's normally.
Well, isn't the lack of the transcript what's the hampering part as opposed to the findings? I mean, the judge does, it is frustrating to us at times to say, don't just tell us what the factors are, tell us about the factors, what you think about the factors vis-a-vis the evidence you heard. But the fellow on the Supreme Court right now, Justice Candy, he wrote an opinion when he was on the second that basically said, even if you don't have the factual findings under the 6108 or 61075, you can't show harmful error absent the transcript. So it's a harmless error. ESAW, E-S-A-W, ESAW.
That would be correct, Your Honor, but there are cases out of this court that treat that matter differently and clearly state that in the absence of factual findings, the Fifth District Court of Appeal says that when there's error on the face of the judgment, and the Fifth District is not alone in saying that even in the absence of a transcript, because the error is so apparent and it does hamper appellate review, that it's still subject to reversal. But I would like to touch on the harmless error analysis.
Well, let me ask, you're talking about the 50 CA, Judge Orfinger wrote an opinion in Right v. Right that's talking about the court must make those findings of fact under the alimony and equitable distribution. However, omitting these findings is only harmful if their absence impedes appellate review.
Correct.
How can our appellate review be impeded when we don't, there's no findings, but we don't know what the findings would be, or what evidence would be there to make the findings without the transcript.
Well, I think, Your Honor, that's exactly the point, which is that how can you undergo the appellate review necessary to determine if a trial court abused its discretion without an explanation as to how the trial judge reached the conclusion she reached? With findings, you may have...
She made all kinds of findings at the end. I mean, certainly the inference is probably not, but that's not our burden or their burden. It's your burden to say, at the end of the day, the judge just told us to get out and I'll send you the judgment, and made no findings, no discussions. I mean, for example, one of the things you talk about is all of a sudden there's this last paragraph of the judgment that says, and oh, by the way, you all stay away from each other.
Correct.
And your argument is that was not pled, so how does that come about? And that certainly facially is a fair thing to wonder why that is, but absent us seeing the transcript that says somehow at the end of the whole trial that was discussed and everybody said, yeah, I don't want anything to do with you, and I'm happy with the no contact thing, how do we say that's reversible error?
Well, we can't know what happened in the trial without a transcript, so on that point...
And I get you're not the one you're the one that's trying to pick up the pieces as the appellate lawyer who was not the trial lawyer.
Correct, but I do want to touch on the harmless error law and that analysis, because I assumed that was something I was going to need to speak about today. There's a Florida Supreme Court case on the issue, and I apologize, I woke up this morning with a cold, so I'm a little congested. The special case, and that talks about how the harmless error analysis is to be applied. When the appellee raised the harmless error analysis in the answer brief, that case was not discussed at all. And so we do discuss it in the reply brief, but the Florida Supreme Court is clear that when you undergo a harmless error analysis, the beneficiary of the error has the burden to prove that the error the appellant's complaining of did not impact the result. And so as we sit here today, it is the appellee's burden, if they want this court to affirm under the harmless error test, that the appellee must carry that burden to show that what the trial court did or didn't do did not contribute to the error in order to be entitled to affirmance under the harmless error analysis. And so here you have a situation where you have at least three overarching issues, really some of the only financial issues that come up in family law: equitable distribution, alimony, attorney's fees, all of which have mandatory factual findings that are required by statute on equitable distribution and alimony. And under attorney's fees, most of the requirements for findings arises out of case law, but there are two basic findings of need and ability to pay.
Well, on the equitable distribution, in your case here, the judge did make findings as to valuation and what's marital asset liability. I mean, granted the judge adopted most of the wife's suggested values and valuation dates or whatever, but the judge is not precluded from doing that.
Well,
So there are findings, I guess is what I'm saying. It's not that the judge said, here's a bunch of stuff, you get that, have a nice day.
Well, there are no findings under the statutory factors. I mean, there is no question that this judgment simply includes a recitation of the factors in the statute.
Yeah, I know. It's not a well-crafted thing.
But to get to, I think the court's talking about the chart of equitable distribution included, where it lists all the assets and all the liabilities that were considered marital and assigns value to those. Absolutely, that's in there. But the problem is, not one of them says what the valuation date was that was used. And so then when you go try to tie that back to the numbers that were used and the evidence that is in the record, because there is documentary evidence that was presented, it's almost impossible to figure out what the valuation dates were, and that is something that's required for the court to identify the valuation date. And I don't disagree, the court has the discretion to use different valuation dates for different assets, but I do think the case law is pretty clear that when you're using different valuation dates for similarly situated assets, like bank accounts, credit cards, things like that, if you're going to use a different valuation date, the court is supposed to explain why, because otherwise, how can anyone looking back in the future say, well, why is this bank account valued as of October and this one valued as of March the following year, when there's no explanation as to why? So I do think it's clear that deficiency exists, and so certainly...
Does that explanation have to be set forth in the final judgment?
I don't think it is a mandatory factual finding the way the statute...
The judge could have explained it at the conclusion of the trial.
certainly that's a possibility.
I
That
don't know that.
we don't know that, but I think what the statute does require, which I think, in the equitable distribution statute, it uses the word shall twice when it talks about the findings that are required, and that does include the valuation date. So while I agree, Your Honor, that maybe the court does not have to put in writing why the different valuation dates were used, the valuation dates certainly at least should be identified, and here, none of them are.
With Judge Kennedy, now Justice Kennedy, and who's been Judge Kennedy on the second DCA, said under section 59041 Florida statutes, no judgment shall be set aside or reversed for error as to any matter of procedure unless it is apparent that the error complained of has resulted in a miscarriage of justice. And basically continues on, there's no general rule that the lack of statutorily required findings constitutes fundamental error. So from this we can glean there's no fundamental error by the fact that the trial judge did not comply with the technical requirements of 61.08 or 61.075, but it's not fundamental error to do so. And then he goes on and says, the most salient impediment to meaningful review of the trial court's decision is not the absence of findings, but the absence of a transcript. And I grant that he was a judge on the second DCA, and they're them, and we're not bound by them. But the overarching thing is he's up in Tallahassee now, so theoretically, if somehow this case goes up to there, he can look at what he wrote. Although we have found over the years, since we've got a number of judges on our court ascend to the Supreme Court, and what they have sometimes said with us, don't say they're on the Supreme Court for reasons I guess they can best explain. But you acknowledge what the problematic position you have is that we're looking at these kind of cases, and you have to show it's harmful error by not doing that, and that our appellate review is impaired. And I'm having a hard time getting past how our appellate review is impaired by saying there's nothing we can look at to see what the judge listened to. In other words, the judge's decision may be completely accurate or completely supportable by competent, substantial evidence, but we don't know that.
And I certainly understand the competing legal issues with the argument that I have to make today. But I think if we go back to...
One of our predecessors, or the grandfather in our court, I think, wrote an opinion 40 years ago that basically, if you're going to take an appeal, have a transcript, you can't really complain when Judge Dowd, who sometimes was a sharp user of language at times, but I'll say it that way.
And I understand, Your Honor, and look, as somebody who does trial level and appellate work, the idea of not having a court reporter, if it's worth having a hearing, it's worth having a court reporter. But
that's actually what he wrote.
I can't, and that has been drilled into my head since my law clerk days, before I was a lawyer, graduated law school. I was working as a clerk for a family law firm, so I certainly understand, and I'm not going to sit here and disagree with you to the extent that certainly we wish there was a transcript. But if you...
I do have some concerns about the life insurance, though, in the sense that reading the final judgment, it seems to indicate that the husband was directed to go get life insurance to secure his alimony obligation. And he's a 78-year-old man, and I'm not quite there, but I'm closing in on it. And that, theoretically, if he doesn't get life insurance, he could be held in contempt. And I'm not, you have to make findings as to availability and cost. And I know how much the state takes out of my pay each month for the insurance I have for my wife when I die, and we got to get rid of this.
And I would say, I think the issue of fundamental error and this harmless error analysis are important because
I don't think there's fundamental error, do you?
I don't know that I would use the word fundamental error in the way it's applied.
Well, that's what we have to do.
Well, I think the case law, which is subsequent to the special case and outlining the harmless error test that's come out of that court since then, even as recently as 2023, I found a case like this court has consistently said that this wholesale lack of findings that are mandatory is enough to reverse a judgment even in the absence of a transcript, because litigants are entitled to a judgment that explains to them what happened. And specifically in the area of family law, I think it's important to point out we have, especially on support obligations, but we're back for modification. And to modify something, you have to prove there's a substantial change in circumstances.
The judge did find here that your client has the ability to pay the financial obligations ordered here, and that the wife has the need for that financial support, right? So
Yeah,
those express findings were made, so
Yes, sir.
this is not a wholesale just, okay, I heard a divorce and you gotta pay alimony and this is how we're dividing it up, and I don't feel like writing anything else, so.
But those statements were in the judgment,
Okay,
certainly.
so, and you have no way of showing us that's error?
The finding that,
Lack of a transcript.
that's correct. I can't say that, and we're not even arguing that there's not an ability to pay alimony. I'm going to go into my rebuttal time a little bit because
That's fine.
there's some point I do want to hit on is that there are certain concessions of error in the answer brief related to some of the not minor but some of the
There's
less
no minor children.
right. Well, that the inclusion of an interest rate,
The extra alimony.
right, but there's also a request in the answer brief for affirmative relief without the filing of a cross appeal, which under
That's
the
a problem for you.
it is a problem in our humble opinions, but it does get to
You don't
the
have to be humble about it. Go ahead.
well, I tried. It does get to the root of this that both sides see problems with this judgment. Both sides filed motion for rehearings, albeit for different reasons, and this is going back at least on some minor points
Did you
because
have a hearing on the motion for a hearing, or was it just summarily?
it was summarily denied. I came in after the original motion for rehearing was filed an amended one before the court had ruled, and then the court
Did
summarily.
your opposing counsel say, hey, by the way, Judge, you do need to fix a few things? There-
I believe, and I don't want to misspeak, but I believe the real focus of their motion for a hearing was on the alimony amount. I do not believe they joined the appellee in bringing the lack of findings
They like the stuff that they.
to the trial court's
They
attention.
didn't like the stuff that she lost $1,000 a month after the judge gave it some thought before to put it in writing.
But I do think that gets us to the point here, which is it's hard for anyone now to understand how we got to the result that we got. It's hard for anyone to really analyze the trial court's thinking, which may or may not have survived an abuse of discretion analysis.
That's the problem, right?
Right, but I think the question is when you have statutes that mandate findings and you have case law, more case law than not saying in the absence of these findings, this judgment's reversible even without a transcript, then if a judgment such as this one gets affirmed, then what is that telling us going forward, when we're trying cases and we're asking for findings and trial courts are saying, well, maybe not, I don't really need to include these. I don't think that's the intent of Florida law, especially on these types of issues that impact people's money. In our case, there's not children, but can affect children. My client's potentially subject to having to sell his home at 80 years old to pay this equalizing payment. There's all sorts of results that come from this.
You may become chagrined to know that our court has become en banc happy of late, and so maybe we need en banc to clear up the case law that you're suggesting we have that says it's per se reversible error to not make these findings and to be consistent with Judge Kennedy wrote many years ago.
And maybe that's the case. I would love the opportunity to argue that at some point. But as we sit here today, I'd like
We already
to...
had one whole en banc oral argument. I think that's about enough we can stand for 1 year.
At this point, if there's no questions...
Some of our colleagues excluded. There's some of them I think would like to en banc something.
Well, I'd like to save the rest of my time for rebuttal unless there's any other questions right now. All right, thank you, Your Honors.
May it please the court, Sarah Glover from Cobb Cole on behalf of the former wife, Peggy
Ms.
Jocelyn.
Glover, your office is in Daytona Beach.
It is correct,
You
Your
could
Honor.
have walked to the OA airport house.
You literally could have walked right past Jimmy John's right down there in their office.
Yes, sir,
They decided
that's-
to make you drive, right?
How did you feel when you got the notice you were picked
I was a
on
bit
at Marion
surprised that when I requested in person that we ended up here. So
County? That's what you asked for.
I did. I regret it. No, just kidding. I'm happy to be here.
It's a good place. Marion County is one of our best audiences there.
Beautiful drive. Can't complain.
About 40.
I did. You never know if it's going to be backed up.
Welcome to my life.
So, I had planned to stand on my brief, but given there's an audience, I have a couple of points that I would like to make, particularly about the oral pronouncement.
Does it say that? I mean, the statute says shall, and it seems to require it to be in the judgment, written into the judgment. And I think Sawyer wrote a case, Judge Sawyer wrote a case that says you can't just do, in essence, what your judge did in this case, saying, I know that this exists and I thought about it, but I'm not going to make any findings as to the duration of the marriage, the standard of living, and ages, all that stuff that's under the statutes. And so, why is your opponent not correct to say, yeah, I have no transcript here, and that's a problem. But you guys have written over the years that says you're really supposed to make these findings. So at the very least, send it back because we have no way of knowing what the judge. Were you the trial lawyer?
I was the trial. I've had this case since
All right, so
2020.
to be fair, we won't ask since you have no transcript. It's not fair to say, oh, by the way, what actually happened. We'll not do that. But
Maybe after. But no. Yes. So I do think that it would be better had Judge Upchurch put in her final judgment the specific findings. But I don't think
required too.
I don't think that an explanation, a detailed explanation for every single one of the factors is necessary, particularly at this level, on the appellate level, as there's been no complained harm. What exactly is the issue that the appellant has with the order other than they lack findings? They just show no harm.
Your opponent said it's harmful error in the brief, or just saying it's not there and therefore it's harmful?
Exactly. That was my position in the answer brief. And my answer brief was, well, was it harmful? How was it harmful? And what outcome did he anticipate having that would have been different? Because every ultimate conclusion made by Judge Upchurch is supported by the record. And in my answer brief, I did go through and painstakingly find.
The judge talks about gross incomes in the context of alimony, and I think I wrote something that says you're supposed to use net income, didn't I?
Yes, Judge. And there.
Good. I'm glad I remember something.
There is a reference to net incomes in the final judgment, but she did not assign a value.
She basically
to the net.
said, okay, he can, based on their net incomes, he can afford what I ordered to pay. Or
Yes.
Something like that.
Yes. And another important finding that she did make specifically in the final judgment was that the husband lacked credibility in both his finances and in his proposed equitable distribution. And the record would support that had been a trend in this case. So
He ended up in jail for 12 days, according to the record.
yes, Judge, that was I requested incarceration time and had not fathomed 12 days, but he did get 12 days.
I think it puts 12. It's a magic number. Did he bond it out? Did he comply at that point with something?
No, it was punitive. It was indirect criminal
All right.
at that point. So this court has since special in the Bowers v. Tillman case in 2021. This court, the harmless error test, the error that can be fundamental on the face of the judgment is not a lack of findings. It's something like an improper comment or several improper comments to juries and closing statements. But again, there is a transcript for the court to review to assess this. And the court in Jerica, which I cited in the answer brief, the second DCA, did find that even though the final judgment in that case just tracked the statutory factors, and that court also made a finding that the husband was less credible than the wife, they still affirmed the alimony judgment in that case. Here, I did raise, outside of a cross appeal, affirmative relief based on the oral pronouncement. Client didn't want to file an appeal, and that goes to the basic.
So can we even address that then? In the absence of a cross appeal?
I believe you should, because I believe that issue is
Should
very
can or different? Can we?
right. I think you can. I think you can as the court. It's the court's prerogative to correct. Similar to in a criminal brief, if someone files an Anders brief and send something back and say, hey, we think you need to look at this issue. I don't think it's...
We just had an en banc discussion about Anders things too. So, like I said, all kidding aside, we have en banc in the way of it. I think we had a couple more circulating for reasons. But no, Anders is a different beast because we are tasked with doing that for indigent defendants. When
Right.
we don't do that in civil cases, saying, hey, I think you missed this one, so pick me. Certainly, we can, under tips and coachman, can affirm on stuff if the record supports it, even if it's not, as long as there's findings made by the trial court that would support it. And I would say you have probably the most congenial panelists to entertain the argument that even if I don't raise it by a cross appeal, that we somehow have jurisdiction to do that. You'd have other members of our court heads would explode to that concept. But that being said, that even though it's there, I think it's a jurisdictional problem.
I tend to agree, but I was going to give it a shot anyway.
There you go.
So that was
for the fence while you're here. Right?
on the face of the final judgment. That was the only inconsistency.
But she did actually. The trial judge did actually explain why she
did
subtract $1,000 from what she orally pronounced, and then said, "Oh, by the way, it's not 2443, it's 1443, and here's why." And say.
Yes, which was a surprise. But it was explained in the final judgment. But that would be the only inconsistency on the face of the
I mean,
final
there would be a
judgment.
difference if there was no explanation. Just she said this, and the number's different. You say, well,
Then I'd be in the similar circumstance where without a transcript, we'd have no way to show what had happened. Which therein, again, lies the issue with the current
do
appeal.
we have case law from the 5th that basically says if you don't make these findings, that we need to send it back for findings to be made, even if it may be harmless? I mean, the certain findings were made. You have a need for alimony. He has the ability to pay. The trial judge don't find his testimony to be credible about anything. These are the valuations I put on the properties. These are the valuations, and this is who gets what, and these are marital properties, and this is a reasonable hourly rate, and this is a reasonable number of hours. I don't mean this. If the blanks weren't completely filled in under the statute that says you've got to do this, make these findings about the duration of the marriage and stuff like that. But
And I did review quite extensively trying to find if there were cases that would require it. And the best I could find would be if the court was concerned about particular findings being missing. In my review, it would be to send it back and have Judge Upchurch fill in the blanks based on the record if she could. I don't think the relief sought, having an entire new trial, would be called for here. Again, my client, her big picture goal is to be done with this case and move on. And I think she has the right for a final judgment to be final.
well,
They have a right to
husband has the
appeal.
right to have a final judgment comply with the statutory requirements that the legislature has set.
Correct. But if there's no harm in the outcome, is it just an exercise to fill in the blanks as opposed to something that is going to change the ultimate conclusion reached by the final judgment that is supported and does have bare minimum findings, but findings that are supported by the record?
If we were to send it back, the judge to make additional findings, absent a whole new trial, can we authorize her to take additional evidence? I mean, without a transcript, is she going to remember all the facts to be able to make the findings?
I cannot speak for Judge Upchurch, but I would say that this was an incredibly memorable case from nearly start to finish. And I
Well, let me
unfortunately...
suggest this. Memorable sometimes in the eyes of the attorneys and the eye of the judges are two different things.
And I would
Some might be forgettable.
And I would agree, but we have had temporary appellate needs hearing in front of Judge Upchurch and such. So we have been back in front of her. There's been additional issues
I'm
ongoing.
not saying that she will or won't remember it. I'm just saying apparently there's no court recorder. So
Right.
she can't order, or somebody can't order a transcript and say, okay, judge, that panel sent it back for you to make findings. Look at the evidence that is in the transcript and make your findings so that we can go forward with an amended final judgment. She's going to have to rely on either her memory and or notes, assuming she makes notes like we used to do in the old days or whatever.
And I would say that I think that I wouldn't know what findings exactly she would need to fill in that would change or make a difference to the ultimate, other than potentially my attorney's fees affidavit saying that he had already paid the difference between the totals. And that again is in the record, my attorney fee affidavit explaining that only the 36,000 was unpaid.
I mean, you look at the alimony thing and say, all right, so we send it back and the judge will say, you make these findings. Okay, I find the duration of marriage was the day they got married to the day they got divorced. I find the standard of living established as middle class, upper middle class, whatever findings based on the evidence. I find that neither party is going to require sufficient education or training to find employment because neither is going to be gainfully employed. I find this is the age. I find this is how their physical condition. I mean, the legislature says these are the things, and I guess I'm trying to figure out, okay, so we send it back and the judge says these things. I don't know how, and I think it's sort of what Judge Harris is, I don't know what then changes anything there.
Correct,
And that goes to the harmless, and it's kind of the yin and the yang that says the statute requires these findings, but then we look at the overarching, the 59.041 that now Justice Kennedy wrote back when we asked the second DCA saying, at the end of the day, that's the big picture that you guys are doing on the appellate courts. You have to say, is the lack of strict compliance with the statute a harmful event here so as to require relief being granted by the appellate court? And with the findings, the limited findings that are made here, it seems more helpful to your position that it's not really a harmful.
Correct, and I would say also that those findings have been previously made. The exact findings that Your Honor is talking about in the General Magistrate's initial temporary relief hearing does go through every single one of those findings. So it would be putting in the filling in the blanks probably from those previous findings.
Let me ask you about the life insurance. The life insurance, how it's the verbiage in the final judgment. I mean, there's a case, I can't remember the name, some case that basically said, when somebody doesn't make the life insurance findings, the ability to obtain it and the costs, et cetera, that can be a harmless error when it's evident from the record that the person already had the insurance and of a higher amount than needed to secure the alimony or child support. Here, it seemed the verbiage in the final judgment is you need to go get the insurance, which again, as my age is advancing, and this guy, I guess, is probably 80 years old now, good luck finding insurance at that age, even if you're in good health. I don't know what his health is because there's no findings. And that is a potential contemptible event if he doesn't do it, because your client understandably wants to have the security so that if her ex-husband passes away, that her alimony is paid.
Correct.
But doesn't her alimony end when he dies?
Well, I believe it would be a vested interest that.
If he's not paid it.
Correct.
But if he's paid it all along, and I know his history so far hasn't been good, but I don't know. We don't know because we have no record as to how he's been doing now. But in other words, if he died tomorrow, and I certainly do not wish him ill, if he died tomorrow and he's been paid up, your alimony ends. Not your client's alimony.
Right. And that's why the life insurance provision was there. And it is in the record. It's on page 74, the beginning of the record. He does list in his financial affidavit a life insurance policy that he pays $25 a month for. So that,
I gotta think $25 a month would not pay for a $100,000 policy. I know this is outside the record and just speaking anecdotally, that probably wouldn't cover $100,000 of coverage for an 80-year-old, 78-year-old. If it does, I'd like to find that company. Or my wife would.
I have no other, except maybe to point out that the no contact provision that Your Honor did mention, it is included in the appendix. The judge did write that it was bound there, and having the
benefit. What about the dischargeability? I mean, the non-dischargeability of debts in bankruptcy. I mean, I get it if people are making a marital settlement agreement and they're trying to, fashion something that hopefully will be persuasive to a bankruptcy judge at the minute you rise. But judges just routinely decide to do that when it's not pled for, and
not often. That is my.
Ever, I would say more ever, in at least my 10 years over there at the appellate land. I get, and I get, it sort of begs the question your opponent is saying, it's all these things are coming out of nowhere here, and they're not asked for, nobody pled, but, you know, you're gonna waive the no transcript thing, which is certainly it, you know, applicant versus Barnett Bank with Tallahassee forward, we all understood that, your opponent said, that since you're a law clerk, you need to have a transcript.
Well, and then I do think that had there been a transcript, it would be very enlightening to why certain provisions are there when certain findings haven't been made, but other provisions are important enough to get written down in the final judgment.
Well, then we can then compare the transcript to what was in the final judgment, and then we could decide whether our appellate review is hampered, because, you know, the things that, and I think Judge Orfinger actually wrote this in that Wright case, and I tell trial judges sometimes when I speak with them is, you know, writing in a final judgment, this is what Bobby said, this is what Susie said, that doesn't tell us anything. We can read the same thing that they said. What it, you know, tell us what it meant to make a finding, and that helps us with the appellate review. If, you know, the trial judge finds that Mr. Jocelyn makes $15,000 a month net income, and we look at the transcripts, it doesn't remotely say anything like that. So, you know, our review is hampered when you do that. We can't see that. That's problematic. Or we don't know, although we have a generic that whatever I've ordered him to pay, he can pay it. Trust me, because I don't believe what he's saying anyways, apparently, or she doesn't find it credible, or whatever the verbiage is. So, you know, your assessment had her hands tied by lack of transcript here.
Well, I have nothing else unless there are any other questions.
Wallace, you have anything to say?
Nope.
Wallace declines to speak. Okay, all right, let me get you back on the clock here.
Thank you, Your Honor.
Well, I just need to tell him. I gave you 154, I must know what you did, so you need to go past that a little bit. Sometimes when we, and I don't say that in jail, sometimes in law school, or law day, or arguments like we're having today, we will ask you generic questions that we don't usually ask in oral argument, because you presume that we actually are aware of the alimony statute and stuff like that. But we ask them to help fill in the blanks for the students who are listening. So 154, if you need to go a little past that, I'm probably flexible.
Thank you, Your Honor. May it please the court.
Yes, ma'am.
I'd like to address the question of, you know, what potentially would have been different, why this lack of required findings is harmful. And, you know, to touch on one thing that the court asked the appellee is, let's talk, you know, the length of this alimony award. You have an 80-year-old man, maybe 78, 79 at the time of trial, ordered to pay alimony for 12 years. That's, you know, there's a lot of questions I think that could go along with that. And because there's no explanation of how the trial court considered.
Well, how long were they married?
12 years.
So isn't that durational alimony?
Yes. Now the law has certainly changed since the trial, but at the time,
Back then. Right?
back then, I mean, yeah, it couldn't exceed the length of the marriage. So, you know, one could assume the trial court just automatically gave her the maximum duration, the length of the marriage. But one of the factors the trial court is supposed to consider when doing that is how old are these people? And so
When he dies, though, his alimony ends, doesn't it?
it's supposed to, but because of the life insurance obligation, and it's not just the lack of findings of the price and the ability
So
to
if he
afford.
dies after the first year, his life insurance will pay the remainder 11 years?
Well, under this order, the trial court's ordered that the former wife or the appellee would receive $100,000 on his death. But to do that, the trial court is supposed to find the special circumstances justifying the alimony award. And here, if you look at the picture of the whole, assuming the trial court's equitable distribution were to stand, you would have a former wife with a condominium in Daytona that was mostly paid for, $176,000 equalizing payment, without any explanation of where that's supposed to come from in 30 days. So you have a person who's going to be set up in that way, plus get another $100,000 upon the death of her spouse.
What about the partitioning of the house in Jackson?
I mean, I believe that's a black and white legal issue, that you can't partition a property located in another county. Now, certainly, may I continue?
Yeah, well, let me ask. So, I mean, if forget about this couple for a second. So, if you had a couple that had 20 different properties in 20 different counties, and they were getting divorced, you're not saying they'd have to file 20 different suits to partition. Couldn't the judge say, "Okay, I'm going to order you all to sell it all and sell it through a realtor or stuff like that"?
So,
Couldn't the judge have done that here and said, "Okay, you need to pay the $170,000 one $4,000 equalizing payment, and if not, we're gonna have you sell the house in Jacksonville to make that payment. Could you have done that? Or she done, excuse me.
I don't believe in the fifth she could have done that. I think, and because
What are you doing in the fifth and so on?
I lost a case in front of this court on that issue a few years back, where in the fifth, if you don't plead for partition, the court cannot order partition of a home. In other districts, they've come to the conclusion that if you simply ask for equitable distribution, that invokes the ability to
Were any
partition.
of us on that panel, so before we do something askew to what we wrote?
I'm going to be honest. You all look familiar to me, but I don't recall if it was from that specific argument because I've been here more than once. So I honestly don't know. And I will say, I don't think you were necessarily wrong, but it's just that is a point where there is a conflict between the districts. And so I think in the fifth DCA, you would have to plead for partition, which you can't do for an out of county property. So I think you would have to ask for equitable distribution. And the trial court certainly could say, husband gets this property, wife gets this property. And then if someone doesn't comply with signing a deed to transfer the property, clearly I don't dispute.
But can the judge say, okay, you owe $170,000, and oh, by the way, if you don't pay within the time frame, we're gonna have you sell that house up in Jacksonville, and from those proceeds, you're gonna have to pay the wife the $170,000 that I've ordered that you owe her.
I don't believe so. I believe
Why not?
the equalizing payment is, there's an analysis of the ability to pay the equalizing payment is required under the law. I think under the enforcement mechanisms provided in family law, if it wasn't paid, then the former wife or the appellee here would certainly have the right to file an enforcement motion and get a money judgment to try to collect that money. But we're talking about a home that's homestead, that's
So
a
what if the husband gets up and the judge makes that oral announcement at the end of the day and says, I can't pay that judge, I'll never be able to pay it. And let's say the home in Jacksonville is worth $5 million, and the judge says, well, thanks for, all right, I'm glad you said that, husband. Before we go, I'm going to add one more thing, one more caveat. If you don't, then that's going to be a lien on your Jacksonville property, or I'm going to require that it be sold within X number of days and to pay at least $100,000. Couldn't the judge have done that as part of the equitable distribution?
I don't believe so under the law, but I guess there may
Is
be
that part of our law? Is that the
some way. I think under any law.
All right.
But I think it does. Not that we want to go down that road probably right now, but it does invoke some homestead issues. But I think that because they each have separate homesteads now. But to me, I think the overarching issue, and I know I need to stop talking here, is you have a final judgment that excludes things that are mandatory per statute, per case law, per the Florida Supreme Court, per this court, and leaves that appellant here with the result that, it's clearly, in his view, harmful with especially on the equitable distribution side without, consideration of his ability to pay this large equalizing payment and things, life insurance that maybe or maybe not he should have had to keep in place. And so we do think under the circumstances of this case, and the Duke case is a case out of this court that talks about this, that the error is so apparent on the face of the judgment, it should be subject to reversal. The former husband, the appellant.
If we want to bring in Supreme Court justices again, you know about Duke versus Duke?
Yes, sir.
You know who wrote a concurring opinion in that case?
I could
The Supreme Court.
I could probably guess by.
Meredith Sasser wrote it and said, yeah, I concur with the result here because that's what Duke says, but it's really stupid.
I understand, and I guess.
Politer, Meredith's much more polite than I am. So, in other words, my point is, when you're saying, boy, these cases are, look at, here's opinions written by people who are now in the Supreme Court who are saying things that probably did not inure to your benefit in the big picture.
And that's certainly possible, but I also think it's possible a judgment such as this one that really has none of the important findings in it is really just the antithesis of what is supposed to happen in a divorce judgment. And I understand
yes, we would prefer that our trial judges would actually make those findings that the legislature says they do, because that makes their job easier and makes your job easier, because that's what the legislatures may not make their job as easy. And I can think of some of our old predecessor judges here in Marion County probably rolling over their graves if they did have to do that now. But that being said, that's where we are.
Yes, sir, and thank you for your time.
Judge Sturgis thought this was a great idea on these findings. Okay. Thank you, counsel. You want to